Judgment in the matter of CAO against the Secretary of State for the Home Department, Northern Ireland.
This case is about the proper approach to assessment of the interests of children who are caught up in the immigration process at two distinct stages. The first stage is when the Secretary of State, acting by her officials, assesses whether a child who is an immigrant should be removed from the United Kingdom or granted asylum. The second stage is when the child appeals against the Secretary of State's decision to the First-tier Tribunal. Article 8 of the European Convention on Human Rights, which applies in domestic law by virtue of the Human Rights Act, sets out an individual's right to respect for their private and family life. In the case of a child, Article 8 requires that the decision-maker treats their best interests as a primary consideration, albeit the decision-maker can weigh these against other matters. Article 8 applies both at the first decision-making stage, involving the Secretary of State, and at the second, tribunal decision-making stage. Section 55 of the Borders, Citizenship and Immigration Act 2009 applies in relation to the Secretary of State and her officials at the first decision-making stage. Section 55(1) places a duty upon the Secretary of State to make arrangements to ensure that any functions in relation to immigration are discharged having regard to the need to safeguard and promote the welfare of children. These arrangements may include the giving of guidance to officials. An ancillary duty is found in Section 55(3), which requires any person exercising immigration functions to have regard to such guidance. The Secretary of State has issued detailed guidance for officials regarding how they should go about gathering evidence and giving consideration to the best interest of children caught up in the system of immigration controls. In appropriate cases, the guidance states that a child should be interviewed. In some cases, it has been assumed that Section 55 imposes duties applicable at the second decision-making stage involving the tribunal. However, as the Court explains in its judgment, this is not correct. Section 55 does not apply at this second stage. However, at that stage, the tribunal is subject to the overarching obligation under Article 8 to treat the interests of the child as a primary consideration. In view of that overarching obligation, which a tribunal can be expected to understand fully and to apply accurately, Section 55 and the guidance would add nothing of substance. In contrast, the guidance and the duty under Section 55(3) have real value at the earlier decision-making stage involving officials, since they are not trained lawyers and will be assisted by being given guidance regarding how to go about their task. The respondent in this case is a national of Nigeria who arrived in the United Kingdom in 2018 with her son, then aged 16, and her daughter, then aged 12, who are also nationals of Nigeria. The respondent applied for asylum for herself and her children. The most significant part of the asylum application related to her daughter. The respondent stated that, for family and cultural reasons, her husband wished to subject their daughter to female genital mutilation, and the daughter would be at risk if returned to Nigeria. By a decision letter issued in 2019, the Secretary of State, acting by an official, refused the asylum application. The Secretary of State was not persuaded that there was a real risk of female genital mutilation for the daughter because the husband had married the respondent, although she had not been subject to that procedure, and he had not raised it with her as their daughter was growing up. There were also inconsistencies in the respondent's account. Further, the Secretary of State considered that, if necessary, the respondent and the children could relocate to another part of Nigeria where they would be safe and would also be able to avail themselves of protection from the police. The decision letter contained a part headed Section 55 consideration in which the Secretary of State considered the impact of his decision on the well-being of the children, having regard to their best interests. Various factors were taken into account. It was considered that it would be in their best interest to be returned with the respondent to Nigeria as a family unit. The letter did not mention Section 55(3) or the guidance. The respondent and the children exercised their right of appeal to the First-tier Tribunal. Evidence about risk was presented to the tribunal. The tribunal rejected their appeal. The tribunal considered that evidence and made its own finding that the respondent and the children did not have a sound basis to claim asylum. Based on the evidence filed in the tribunal, the tribunal came to essentially the same conclusions as the Secretary of State regarding the absence of risk in relation to the daughter. The respondent appealed to the upper tribunal. At this stage, she complained that the Secretary of State had failed to comply with the duty in Section 55(3) and the guidance, and that the First-tier Tribunal had erred in law by failing to take this into account. The upper tribunal dismissed the appeal. It held that the First-tier Tribunal had made no error of law. The respondent appealed to the Northern Ireland Court of Appeal. The Court of Appeal allowed the appeal. It held that the Secretary of State's failure to refer expressly in the decision letter to the duty under Section 55(3) and the guidance meant that the inference had to be drawn that the Secretary of State had breached that duty. According to the Court of Appeal, this meant that there had been an unlawful interference with the Article 8 rights of the daughter at the first decision-making stage, and that problem had not been recognised in nor remedied by the First-tier Tribunal's decision. That was so even though the First-tier Tribunal had properly assessed the best interest of the daughter for itself and had found that returning her to Nigeria would be compatible with her best interests. The Court of Appeal ordered that the case be remitted to the First-tier Tribunal for reconsideration. The Secretary of State has appealed to the Supreme Court. The Supreme Court unanimously allows the appeal. It holds that the First-tier Tribunal committed no error of law in its decision. It applied Article 8 properly, as it was required to do, and had regard to the best interests of the respondent's daughter as a primary consideration. This court explains that an appeal to the First-tier Tribunal against the Secretary of State's refusal of an asylum application is a full appeal involving fresh evidence and a completely new decision taken by the tribunal on the basis of its own independent assessment of the merits of the case. The duty on the tribunal is to comply with the Article 8 rights of the child by treating their best interests as a primary consideration. The First-tier Tribunal had done just that by making its own findings in the light of the evidence adduced before it. Since the second decision-making stage involved a new decision by the tribunal based on new evidence about the best interest of the daughter, that decision superseded the decision made at the first stage by the Secretary of State. Even if there had been a failure by the Secretary of State at the first stage to comply with his duty under Section 55(3) of the 2009 Act and with the guidance, that would not show that there was any unlawfulness on the part of the tribunal in making its decision. The tribunal is not subject to the Section 55(3) duty and is not required to follow the guidance. It is required to act in compliance with the child's rights under Article 8, and it had done that. The respondent and her daughter had been represented by a lawyer. The tribunal was entitled to expect that all relevant evidence in support of their case was presented by them. The tribunal did not have any obligation to require the daughter to give evidence about the risk to her. The daughter, a young child, would not have been able to give additional evidence which would have assisted the tribunal in its consideration of the risk to which she was subject. The court also refers to other aspects of the rights under Article 8 to explain that they too were satisfied by the decision-making at the tribunal stage. Article 8 requires that a person affected by an immigration decision should have a fair opportunity to make representations. The respondent had a fair opportunity to do this at the tribunal hearing on behalf of herself and her children. The tribunal's decision was also in accordance with the law, as required by Article 8, because the tribunal complied with domestic law in making its decision, which is the operative decision in this case. The court also explains that in any event, looking at the decision made by the Secretary of State at the first stage, there was nothing unlawful in the way it was made. It is true that the decision letter did not refer expressly to the Section 55(3) duty and the guidance, even though they were relevant at that stage. However, the substance of the decision letter showed that the matters referred to in the guidance had in fact been taken into account. That was sufficient to show the decision was lawful. Although the guidance referred to children being interviewed in appropriate cases, the Secretary of State's officials were entitled to consider that this was not an appropriate case where an interview of the daughter was required. The Court of Appeal was wrong to say that there had to be an express reference to the Section 55(3) duty or the guidance in the decision letter. Nonetheless, the Court explains that it would be best practice for the Secretary of State to include such references in her decision letters. For these reasons, the Secretary of State's appeal is allowed and the order made by the Court of Appeal is set aside.